Okay, so as Karen said, thank you everyone for joining us this evening. My name is Amy Lee Hogan-Simonovich, and this is Karen Connolly. We are attorneys with Ridge and Downs, and we're so happy that you guys decided to spend a little time with us tonight. If you're new to the Zoom webinar format, you will notice that there is an option on your screen with a Q&A box. You can ask questions in that box. I believe it's like anonymous, so it doesn't show the rest of the participants who's asking which question. There's also a regular chat function that you might be more familiar with. And if you have trouble with either of those, I believe there's also a raise your hand button, and I can unmute you to speak.
Please feel free to ask your questions at any time. Send them out in the middle when we're talking about something. There'll be a time to ask questions at the end, of course, but feel free to ask during the presentation. We're happy to answer any questions you might have.
Okay, so with that being said, we're going to go ahead and get started. What I'm going to do is I'm going to share my screen with you. We have a short little PowerPoint prepared, and Karen and I are going to go over some things with you. All in all, we don't expect, it to take longer than 30 minutes. So we'll get you in and out of here tonight. Great. Okay, is it up on the screen?
It is.
Okay, so as I said, Karen and I are with Ridge and Downs, and we practice injury law, representing injured people in workers' compensation, personal injury, and FELA, which is railroad injuries. So you're probably not too familiar with that. And Karen and I are going to talk to you today about the amendment that the legislature made to the Illinois Occupational Disease Act to incorporate some new rules with regards to contracting COVID-19 workplace. So I know a number of you, when you signed up for the webinar, sent in questions, and everyone is very, very concerned about the safety in school, starting school in person. And what Karen and I are going to be focusing on today is what the law provides for you if you do contract COVID while working. And some of the other questions that you guys sent in about some of your other safety concerns and how to kind of prevent getting COVID are going to need to be directed back to, your council presidents and leadership that way. What we're going to focus on today is more the unfortunate circumstance where those safety protocols fail and somebody does contract COVID. So I just want to make sure that that's clear for you. One of the first things you might be asking yourself is, why workers' comp? What does that have? How does that come into play if I get COVID? So Karen's going to explain a little bit about just what a workers' comp claim means and what that would provide for you.
This is just a little basic overview of workers' compensation and occupational diseases under the law. And this is the things that you're entitled to, whether your injury or occupational exposure has anything to do with COVID, or if you trip and fall in the hallway or get knocked down by a child. The first thing that you're entitled to is the right to medical treatment. When you're injured at work, you have the right for your employer to pay for your medical treatment to get you better. It's limited in a few ways, mostly in that you can see 2 doctors of your own choice. You have the right for the doctor that you see to refer you down to other doctors, but that's basically the most significant limitation of that right. You have the right to the payment of weekly benefits while you're unable to work because of your injury. That would be 2/3 of your average weekly wage during the time that you're unable to work. And then lastly, you have the right to what's called permanent partial disability benefits. And that's a settlement or an award designed to compensate you for the disability that you suffered as a result of your injury.
Okay.
Just as a review, in order to come under the Workers' Compensation or Occupational Disease Act, you have to have an accident. the incident that we're talking about must arise out of and in the course of your employment, and that deals with the risk associated with what happened to you. There has to be a causal relationship between the accident that you had and the injury that you are alleging, and the injury that's causing the need for you to be off of work and for you to require medical treatment. And then we talk about having lost time, that we have some issues with proof for that also.
So the amendment that was added to the Occupational Disease Act provides that if first responders and frontline workers contract COVID-19, there is a rebuttable presumption that the disease is related to their employment. And this presumption applies to both the accidental exposure and the causal relationship between the exposure and the employment. So that's a lot of legalese for you. So let's talk about what a rebuttable presumption is. This is an assumption of fact accepted by the court until disproved. So it is not kind of an automatic slam dunk, right? It doesn't mean you automatically win the case, but what it is a bit of a helping hand in terms of the proof that you need for your case, okay? And Karen, who is covered by this presumption?
All right, well, the first part of the presumption covers first responders. Those are police, fire personnel, EMTs, paramedics, anyone that will be considered a first responder, and healthcare workers, including people who work in nursing homes, hospitals, healthcare facilities, rehab facilities, and it also covers correctional officers. There's a second group of people who are frontline workers. These are individuals employed by the essential businesses, employed in essential businesses and operations that were defined in the executive order that was dated March 20th, 2020. And while the first responders don't have to prove these other things, if you're a frontline worker, you also have to show that the individuals are required by their employment to encounter members of the general public, or they are required to work in employment locations with more than 15 employees. We have section 12 here that talks about essential businesses and operations. They specifically refer to educational institutions, public and private schools, pre-K to 12, colleges and universities are covered. So I think that everyone here that's attending is going to be considered to be an essential worker under the provisions of the executive order. I think that almost everyone would meet the provisions of working with the public. That would be the students, of course, and most schools have more than 15 employees. And they're not talking about just teachers. It's maintenance personnel, custodians, administrative personnel. So I think that almost everyone we're talking to would meet either one or the other of those requirements.
So next we have to talk about what evidence can rebut the presumption. And there's three main ways that an employer can rebut this presumption so that it's no longer an assumption that your COVID was work-related. And the number one option is that the employee was working at home or on leave from the employment for a period of 14 days immediately prior to the injury or exposure. So if you're working at home and you're not actually working, in the school building and for 14 days prior to contracting COVID, the employer can use that to rebut that assumption that your COVID was work-related since you had been spending that time at home. The second way that an employer can rebut this presumption is by showing that they were engaging in and applying to the fullest extent possible or enforcing to the best of its ability industry-specific workplace sanitation, social distancing, and health and safety practices based on CDC Illinois Department of Public Health guidelines for at least 14 days prior to the injury or exposure. So this is a very technical requirement, and there's a lot going on here because you'll notice that this is kind of a constantly changing environment, right? The industry-specific guidelines that applied in April are not necessarily going to be the same guidelines that you're being sent back to school with. Now, many of you may be familiar with the joint guidance that was issued by the Illinois State Board of Education and the Illinois Department of Health. There's a Part 3 joint transition guidance. It's on isbe.net if you haven't read it yet. And so that is going to be part of that Illinois Department of Health guidance that the statute references. If the employer school can show that they were following this guidance, okay, to the fullest extent possible, to the best of its ability, they can use that to rebut the presumption. Now, an example of this is obviously in schools, all individuals are going to be required to wear face covering. So if that's not being enforced, right? If that's one of the guidelines not being enforced, these are things that are going to become very technical and change over time. There was an update to this guidance that was posted just yesterday on isbe.net. So these things are going to be a lot to kind of pay attention to as we go through the school year. So the third way that we can see the presumption rebutted under the statute is by an employer showing that the employee was exposed to COVID-19 by another source. Now, this is information that is definitely going to come through monitoring of social media feeds, right? We see this a lot in workers' compensation cases. Employers are very able to get their hands on social media. You might think you have it under a different name or that you're private. They get their hands on it. People that you may consider your friends, that your acquaintances, that you work with, that are on your social media, these things get turned in, okay? So be very careful with regards to social media use. I'm sure many of you are already working in education. But if you've got social media out there that you're out at parties and, big backyard barbecues and I don't know, all those things, right? That can be used as evidence to rebut the presumption and that assumption that your COVID was work-related, because they can show that there's a competent other source for where the infection could have come from. Karen?
There's several rules if you want to fall under the presumption. First of all, with respect to diagnosis, before June 15th of 2020, you needed to have a confirmed diagnosis by a medical professional or a positive laboratory test or antibody test. That is because the testing was so difficult to come by at that time. After June 15th, it's necessary to have a positive laboratory test or antibody test. Also, there's a time frame that this falls between. The presumption is valid between March 9th, 2020 and December 31st, 2020. So if your COVID falls outside of that time frame, it's not, the presumption is not going to apply. Let's see, I have a question. Let's see. Considering frequent changes to number 2, if there is an update change in practice within 14 days and the person gets sick under the previous rules, is that presumptively rebuttable? I'm going to say probably not. I mean, I think that the presumption would apply, or certainly arguably. How about arguably?
And I think that brings us really well into the next point as well, Karen, which is just because the presumption doesn't apply or the presumption is rebutted does not mean that we still can't prove it the good old-fashioned way under the Illinois Workers' Compensation and Occupational Disease Acts. Okay, so like we talked about in the beginning, that presumption just gives you a leg up in proving your case. It does not mean that your case rises and falls on that presumption. Okay, so we can still prove that it's more likely than not that this exposure was at work, just because they're following safety protocols as to the best of their ability, that sort of thing. And it may not be assumed as a fact that your COVID was work-related, but we can still prove that it was. What do we need to have to prove that? So obviously, you're placing this is important even with the presumption. So I'm going to switch to the next slide for a second. Karen and I want to make sure that you don't want to just assume this presumption is going to apply. You want to be proactively keeping track of things that can affect your exposure. So how many kids are in your classroom, whether the kids are failing to wear their masks correctly, maybe other staff members are failing to wear masks correctly, exposure to students or staff that end up testing positive. So if someone in your room, tests positive, these are all things that you need to keep track of. The cleaning practices that are being used, if you feel your room's not being cleaned. We don't want to be in a situation where you unfortunately contract COVID-19 and then you're scrambling to try to remember all the things that happened. So keep a journal, keep a diary, make sure you're writing these things down, store some notes in your phone, whatever you need to do to make sure that if there are incidents, where a student takes off a mask and coughs in your face, that you have that written down to use later for us to go back and show, okay, this is, where the exposures happened and, that PPE failed, right? The second thing you're going to need to do if you come down with COVID symptoms is seek a medical diagnosis. As Karen explained, you do need to have a positive test result at this point in order to go forward with showing that COVID is work-related. You also, when you go to the doctor and seek medical attention for this, will want to have paperwork with regards to your work restriction and your off work. Obviously, you'll be off work for at least 2 weeks, but you want to make sure that that is certified by the doctor and that the doctor is authorizing you off work as long as your symptoms or your condition requires. And this is what allows us to get you paid for the time off under the workers' compensation claim. And finally, in a case, we would also look for evidence of permanent disability, if any. And, there's so much unknown about this virus right now, and I don't think really have all the answers about what the lingering effects are going to be. But certainly, if you are having residual effects, from contracting the virus, this is something that, we need to be paying attention to as well, and making sure that, that is also considered a factor in your case.
And they need to be medically documented. I have a client right now who woke up from a coma after being intubated for 2 weeks that has very limited use of one of his arms. They don't really know why. They don't really know how that's related to COVID, but the doctor says it's because of his infection, maybe how he was positioned. But, we need to document the physical therapy that he's going to, the complaints that he has to the doctor. If you have shortness of breath, if you need supplemental oxygen, all of those things are really important to keep track of and to document.
Oops, I went one too far. Oh, geez. There we go. Karen, you're up.
Oh,
can you see my slide, Karen? Sorry, we had a bit of a
We just want to give a reminder. Amy Lee said at the beginning, and we want to just give you a reminder that the Workers' Compensation and Occupational Disease Act only applies after a COVID diagnosis. There are a lot of tools, though, that you can use prior to an exposure or to contracting COVID, if you have pre-existing conditions, if you have concerns. There's the Family Medical Leave Act, the Americans with Disability Act, there's things under your union contract. So don't think that I'm completely I'm completely alone until I get sick and then, No, there's other tools that are out there that will help you, but this is to provide you with information in the unfortunate circumstance that you or someone that you know comes down with COVID-19.
Okay. So Karen and I have our contact information up here. If you think of additional questions or you have questions as the semester begins and goes on, I have our email addresses up here. Ridge and Downs also has a website, as well as a Facebook page. You can like us at Ridge Downs, and I try to keep a lot of developing information coming out and posted on that website and Facebook page. So for example, the presumption right now only goes through the end of the year. If there's going to be legislation to extend that as the pandemic continues, those are updates that we will keep posted to our Facebook and website so that everyone knows about any changes going on in this area. We also, talk about lots of other work-related topics as well, besides just, what's going on with COVID, although that's really the forefront on everyone's mind right now. So I'm going to go ahead and stop sharing my screen, and Karen and I can answer some more questions for you.
Yes, and I do believe too that Amy Lee will send you a copy of this webinar so you can refer back to it.
Yeah, everyone who attended live here today, as well as a number of people opted to, weren't able to make it tonight and will be wanting to opt for the recording. We have a YouTube page for Ridge Downs. I'm going to post it there, and I'll be sure to email it out to everyone who was here with us today. So if you did find it helpful and you have any friends or family that might also find it useful, feel free to share it with them. We have some other recordings up on the YouTube site as well. We've done this webinar specifically for firefighters, police officers, other types of frontline workers, and now we're doing it today for educational staff. So there's a couple nuances depending on which industry you might work in. So keep that in mind as well. If you have any friends and family that have concerns, it's not just a concern for our educators right now. So let's see, what else?
There's another question. What should people do if they contract COVID from work and spread it to their household family members?
Yeah, so I've unfortunately seen this happen, and right now, the way the Workers' Compensation Act is written is that the benefits are only applicable to the individual who contracts the virus at work. So the benefits of the Workers' Compensation Act and Occupational Disease Act that Karen and I outlined for you today, unfortunately would not be available for other members of your family. They would have to look to other options with regards to the FMLA, the emergency, the COVID-related FMLA. I always forget the acronym for that. They added a couple more letters. And see what other options they might have available to them, but they would not be entitled to similar benefits from the Workers' Compensation Act.
No, and I do believe that most group insurance is covering COVID-related exposures and contraction of the disease. I have not seen that denied by a group health carrier yet, but one never knows.
But certainly, with regards to the time off they're going to need and things, it does certainly, become an issue for people. And, that is a concern for a lot of families trying to make ends meet.
Let's see. I don't think we have any other questions. Check one more place.
I was going to say, did you check the Q&A and the chat? Because people kind of do it different ways.
Oh, no. nothing different. I think that's all we have.
Okay. All right. Well, if nobody has any other questions, like I said, feel free to reach out to Karen and I if you have any individual questions, or you think of anything else. And thank you guys so much for spending some time with us tonight. We hope you found it helpful, and we really pray that you guys won't need us. Best of luck.
Yes, thank you.